I'm sure CLAT PG 2022 is over, and I hope you must have done very well. And here is our first analysis of the paper. As you see, there are 120 questions divided into 20 paragraphs. The first paragraph is on family codes, right? And the judgment is Aman Lohia versus Kiran Lohia. There are 6 questions, obviously, for each paragraph. And out of these 6 questions, 3 are easy, 3 are moderate. And so the difficulty level of this particular paragraph is 3 easy and 3 moderate. Second paragraph is on section 304B of IPC, and it comes from Gurmeet Singh versus State of Punjab. Also, there's a reference to Satbir Singh versus State of Haryana. And again, there are 6 questions. 1 is difficult, 2 are moderate, and 3 are easy. And this case, we've already covered in Lex Templum. And right, so also the family court judgment is not that difficult, even if you have not read Aman Lohia versus Kiran Lohia, but based on your family law understanding, the subject understanding, basically, you could answer these questions. The third paragraph is from Amit Sahani versus Commissioner of Police. For this also, the difficult questions were 2. A moderate 2 and easy 2. So if you have read this case properly, you could easily answer the questions. Then this has also been covered. Then the fourth paragraph is from circumstantial evidence. The difficulty level, there's no difficulty level as such. So all of the questions, like 6 questions, were easy. And this is a conceptual part which has already been covered in our class. The fifth paragraph is of Contract Act. All questions are again direct. All of them are 6. All of the 6 questions were easy. Again, this is a conceptual part and which was already covered in our class. The next paragraph, that was the 6th paragraph, is from Lok Prahari versus Union of India case. And it is on appointment of judges, right? And most of the questions were static. So I would say easy questions 2, moderate 2, and difficult 2. Again, this case is covered in Lex Templum. The 7th paragraph is a judgment on Gautam Navlakha, and obviously we have covered this case in great detail. If you have read this case, I wouldn't say there was any difficult question, but since again I'm assuming the general crowd, and I would say 2 were easy, 3 were moderate, and 1 difficult question. Then the paragraph 8, that comes from Association for Protection of Democratic Rights versus State of Bengal. Again, this is easy paragraph. Just 1 difficult question, 1 moderate question, and 4 easy. 9th paragraph is about right to drinking water. This is usually, this is constitution plus human rights. And I have been mentioning this time and again in our classes that you need to know human rights part as well. So this was moderate, but assuming the general crowd, I would say 3 were difficult, 1 was moderate, and 2 were easy. 10th paragraph is from jurisprudence. And to be very honest, all of the questions were too easy. If you read the paragraph carefully, you could answer all the 6 questions, right? So obviously English comprehension is needed for paragraph 10. Then paragraph 11. This is on judgment that was given during pandemic, and we have covered this in Lex Templum. And this is again on moderate scale. 4 were moderate questions and 2 were really easy. So this was, doable, this paragraph again. Then the 12th paragraph, again, this was on contract law. This was covered in Lex Templum. 4 were difficult, 2 moderate. Then 13th paragraph was on Juvenile Justice Act, and this paragraph was analytical in nature. All the questions are analytical. So 2 were difficult, 1 was moderate, and 3 were easy. Now, this was a general paragraph on juvenile justice. Then the 14th paragraph was from international law, and questions are difficult in nature. So 4 were difficult and 2 were moderate. Then the paragraph 15 was related to repugnancy of Central and State Act, which we have covered in great detail in Lex Templum again. So I would say all the questions were easy, but considering everybody's preparation, I would say 3 were moderate and 3 were easy. Then comes paragraph 16. This is on jurisprudence, and all the paragraphs, all the questions were really very easy because everything was covered in the class. Then comes 17 paragraphs. Now, again, this is from international law on International Court of Justice. So I would say 4 difficult questions were there and 2 moderate. It was not an easy paragraph to do. And then 18th paragraph was on amalgamation. It was a difficult paragraph, to be honest. So 4 were difficult and 2 were moderate. 19th paragraph was on maintenance from Rajneesh versus Neha case. This is again covered in our classes. I would say all of them very easy if you have read the case properly, but I would say just 3 easy and 3 moderate. Then comes the last paragraph, that is the 20th paragraph, that was from Union of India versus VKC Footsteps India. This is again not that difficult, but 1 question was difficult, 3 were moderate, and 2 were easy. So in our analysis, Lex Templum's analysis, I would say 33 questions were difficult, 40 were moderate, and 47 questions were easy. So paper is on easy to moderate. So at the first glance, with our analysis, the safe score will be net 65 positive attempts for top 5 NLUs. And cutoff will be somewhere around 60 to 62. However, in few days, we will conduct a detailed survey and provide you the more approximate cutoff. Okay. So now this is about the analysis of the paper and the cutoff and the difficulty level of the paper and the safe score. Now, just let's discuss few of the paragraphs for which we have already done an analysis, and let's see what are the answers. This is the question paper that you're seeing on my screen. Now, first paragraph is a family code paragraph. Okay. Now, the answer to first question is C. Now, I'll not disclose the answer, but we will quickly discuss that how would you arrive at an answer. Now, question asks, which of the following is not correct about the Family Codes Act 1984? Okay. Now, if you have, if you have read the Family Codes Act, or even if your family law knows, you would easily answer this question, that the duty of the family code is to arrive at a settlement between the parties where it is possible and consistent with the nature and circumstances of the case. So this is an easy question. Now, next, again, they have asked that this paragraph is from which judgment? And I've already mentioned this is from Aman Lohia versus Kiran Lohia. Now, the third question is based on this paragraph itself, wherein it is asked that which of the following was held by the Supreme Court of India in relation to the family codes. Okay. Now, again, as I said, if you have read the questions, the paragraph, you will get the answer to this. The answer is A for this. Now, for fourth, again, the family court must adhere to the norms prescribed by the statute with regard to the adjudication of matrimonial disputes, and also to the, again, this is a static question, but this question, all the 6 questions have been discussed in that particular case, that is Aman Lohia. So answer to that question is B, fair procedure and natural justice. Okay. Now, answer to 5th is A, and answer to 6th is nikah as per Muslim personal law. Now, see, I'll tell you, for 6, some of you might have found it really very difficult and all, because this is not discussed in the judgment directly. But if you read the judgment properly, they have discussed a particular section of the family codes, 2 or 3, wherein they have mentioned in which cases the family codes would have jurisdiction, right? So if you have read that part particularly, you would easily answer this question. And even if you haven't read it, again, it's really very easy, because Family Codes Act will come into picture when, when you're married, after the marriage. And it is saying nikah as per Muslim personal law. So just first step before marriage, that you're performing nikah and all that. So some questions are, even if you have not read that particular case, and even if you know some things about family law, you could easily answer the questions in this. Now, paragraph 2. Now again, this paragraph is on 304B. The answer to first is C. Now, remembering judges, obviously, it's a difficult task. We've already discussed in the class, but anyway, that was expected. They would definitely ask who is the judge for this particular case, because that's a tricky part, and obviously we're going to lose our marks in that. Gurmeet Singh is the case we've already covered in the classes. So answer to this is C. It's I wouldn't say this is easy. It's difficult if you have not done it. I mean, it's difficult to remember the judges, right? Now for answer to 8 is A. Again, this is a very straightforward and a direct question. Even you don't really need to know Dowry Prohibition Act 1961, but even if you have read section 304B of IPC and Satvir Singh, which is a landmark case on that, you will find mention of section 2 of the Dowry Prohibition Act 1961. So I think that's an easy question. The 9 for that answer is A. Obviously, because this is again discussed in Satvir Singh and this Gurmeet case that we are discussing, the presumption as to dowry death provided under section 113B of the Evidence Act 1872 is a shall presumption. That's true, right? Then for 10th, the answer is B. That is the gravity of demand of dowry, including the existence of burns of injuries inflicted while making such a demand. So this is an easy one. Then comes your 11th question, and for that answer is C. Maybe homicidal or suicidal or accidental death. Again, this has been discussed in Satvir Singh case, which is a landmark case on section 304B, and again in Gurmeet that has been referred. Now 12 is a tricky one, but it's an easy one. Answer is C. Again, that's given in the judgment itself. If you have read that Gurmeet judgment properly, you could easily answer 6 questions. Now the third paragraph, it is about peaceful protest, and the case is Amit Sahani versus Commissioner of Police, right? For 13th, answer is D. Then again, 14th, most of you might find this very difficult, but to be very honest, 14th is not a difficult one, because all these cases have been discussed in Amit Sahani versus Commissioner of Police. So if you have read Amit Sahani, you would easily answer this question. So answer to 14 is B. Now 15th answer is A, and this case I have been discussing time and again in our constitutional law classes. Even though you might say that, ma'am, this is 2012 case, I've already told you that link. There's going to be a link. Nothing is, isolated. Everything is just connected. So even if you have not read Ram Leela Maidan incident case, that's some way connected to Amit Sahani case, right? Somewhere at the periphery. And this is very important. And this case is very important. I have mentioned this when we discussed Article 21, that Ram Leela Maidan case is about right to sleep being a fundamental right. So if you read the options carefully, obviously, you will easily answer this question, and answer is A. Then answer to 16 is B. This is again, now most of you might have done mistakes in this question, which, some of you approached me and, you have made mistakes in this. They have asked which of the following statement is not correct, right? Is not correct. So you have to choose the statement which is incorrect. And that answer is B. So this is a tricky, confusing question, and if you won't read it properly, you will lose marks. Then for 17, answer is C, Kameshwar Prasad. Now this is again I have mentioned in the constitution classes. This case we have covered in landmark cases. Answer is C, Kameshwar Prasad versus State of Bihar. So this is very easy case. Now again 18th, again this is memory-based question. I mean, you have to remember the name of the judges, and answer is C. Now, paragraph 4 is about presumption of, paragraph 4 is about circumstantial evidence, and answer to 19 is A. Okay, and this is directly asked from the BEAR Act. I think section 106 subclause A. Okay, so this has been directly asked from the BEAR Act. So if you have read the Evidence Act properly, you could easily answer this question. Now, question 20 is presumption of innocence. The answer is B. Obviously, this is again very easy. Whenever we start studying criminal law, we know the basic things about criminal law, and so answer is B. This is an easy. So is of a circumstantial nature. The circumstances from which the conclusion of guilt is to be drawn should be fully established. Again, a very easy one. I mean, it's easy, but if you find it difficulty in solving this question, then for that you need to have your criminal law fundamentals to be very strong, but this is fully established. 21. Then 22 is answer for 22 is D, that is both A and C. This is again very easy one. Answer to 23 is C, that is dominant. Answer to 24, again, this is a very, very direct question. So it's B, section 105. Now, paragraph 5 is about contract, and all the questions from this particular paragraphs are very, very easy. Okay. So for 25, it's B, refer to section 32. For 26, for question 26, it is answer is A. For question 27, answer is C. For question 28, it is D. For 29, it is C. And for 30, it is A. Okay, so these were the answers to these 5 paragraphs which we have analyzed at Lex Templum. Now, let me just quickly go through the paragraph of jurisprudence, because we have covered jurisprudence in great detail in Lex Templum. And I would just like to, tell you that how you could have achieved 12 out of 12 in jurisprudence itself. You don't really have to mug up things in jurisprudence if you have understood the concepts. Now let's see at the question number 55, which says which of the following statements regarding the morality of aspirations is untrue, right? They have asked which of the following statements are incorrect. Now, all the answers you will find in the paragraph. Okay, you don't really have to know the things here with respect to paragraph 10, but all the answers are there in the paragraph. So what will be the answer to this? Untrue, which means incorrect, right? So answer to 55 will be D. The law cannot compel a man to adhere to the best of his human capabilities, because first is true, the morality of aspiration is based on inevitable rules for ordered social living, right? Second, it does talk about perfection and excellence. You will find that in the paragraph again. Third, the law cannot regulate the morality of aspiration because it is subjective in nature, right? So all of these 3, that is A, B, C, are true, and only untrue statement is option D. Now let's come to 56. The rules for morality of duty command. Again, you will find this in the paragraph. Answer is D, to conduct necessary for social living. 57, right? Both A and 2 are true. That is again from the paragraph itself. 58, this is again from the paragraph itself. Answer is D, knowledge regarding the circumstances. Now 59, the concept of duty as characterized by Fuller seems what dynamic, right? Because he did talk about it in the paragraph itself. So answer is A. Now 60, Well, this is based on my understanding of the paragraph and from the paragraph itself. Okay, so the keys of CLAT might differ just in case. So now 60, which of the following statement is not true? Again, they're asking incorrect statement. So what is incorrect statement? Morality of duty is non-obligatory is incorrect statement, because you will find the mention of B, C, D in the paragraph itself. Okay. All right. So 11th is the paragraph that we have covered in the class, but I'm not going to discuss the key for that as of now. Let's go to the second paragraph of jurisprudence. Yes. Now see. Sorry, 91. Validity of law resides in the political sovereignty of the maker of that law refers to. So now when you read the statement, validity of law is there in the political sovereignty. Austin, Bentham, Kelson, Hart, everything should strike to you, right? So answer is legal positivism. Now 92 is norm cannot become legally valid unless its content is fair and just in accordance to norm. I told you, remember the catchy words, very, very important words, so that you will easily tick mark the correct answer. Norm. What it could be? Kelson, right? So answer is A, legal positivism again. It is saying a norm cannot become legally valid. So you remember the pyramid that I taught you in the class? The lower norms give validity to the higher norms, isn't it? So it's that. So this comes, Kelson belongs to positivistic school. So the answer is legal positivism. Now 93, the falsehood of legal positivism resides again. I'm not going to read this whole para, but if you identify the keywords in this, what are the keywords? Rules. I told you, I have literally covered everything about Hart in the class about rules. So answer is HLA Hart. Okay. Now 94. Principles requiring that laws be general, public, prospective, coherent, clear, stable, and practicable are indispensable to lawmaking correspond to. Inner morality, it's Hart's concept, right? Obviously, it's not the answer. Democratic lawmaking, no. Method of logic, no. So answer is C, legitimacy and transparency in lawmaking. 95, I mean simply that history in illuminating the past illuminates the present. And in illuminating the present, illuminates the future. Now, Comte, no. Dubois, no. Pound, no. Because sociological engineering, sociological school, they all three, A, B, and C, all three are from sociological school. So what's remaining now? Cardozo, he's from the realist school, right? Realist school looks towards future. I told you, right? And that's why the answer is B. Again, very easy. Now the last question, the life of the law has not been logic, right? Obviously not Dworkin, he talks about taking rights seriously, not Amartya Sen because he talks about Indian philosophy and all that, and not Cardozo. Then what could be the answer? It's Holmes. Again, Holmes is from the realist school, but Holmes is the answer for this again. So that's what I keep saying in the class, and I'm again saying this. If you read jurisprudence properly, if you understand the concept, you don't really have to mug up the things. You just have to remember a few words, important words, and make your understanding very, very clear on it. You will definitely score out of marks. Like in this, if you have studied it properly, and even if you have not, but if you have remembered the words properly, you could easily get 12 out of 12 in jurisprudence itself. And that would give you, an edge over other students to score more and to get a good rank. All right. So that's our analysis for 7 paragraphs, and we haven't done it for the rest because we are waiting for the key. And once the key is out, we will analyze it further, and then we will release our detailed analysis about the cutoff and everything. Because last time also when we analyzed the paper and we predicted the cutoff, with utmost accuracy. I mean, the accuracy was 100% by Lex Templum when we predicted it last year and last to last year. So this year also we will come up with an analysis which will predict the cutoff and how much marks you have to score. But prima facie, it looks that 61 to 65 is a safe score to get top and edus. All right. So, all right then. Thank you for watching this video. Have a good day.